Hello and welcome to the world-famous and award-winning Driving You Crazy podcast. This is the show where we talk about all things transportation, anything to get you from here to there. I'm the traffic anchor and the transportation reporter for Denver 7 News, Jason Luber. If you would like to contact me, all my contact links are in the description of the show. You could call the listener hotline at 303-832-0217, and you could rate the show on your favorite listening app, and I would appreciate that as well. So recently I saw a post from our Colorado Department of Transportation saying this: over half of drivers refuse to be tested upon arrest for a DUI. Subheadline: new CDOT campaign to educate drivers on the expressed consent law. I thought to myself, okay, and then I read the first sentence. And it goes like this: Colorado has seen an increase in drivers who refuse a blood or breath test following a DUI arrest in recent years. Of the 12,994 law enforcement contacts for impaired driving in 2022, more than half, 54%, resulted in toxicology refusals. I thought again, okay, that's pretty interesting. But then here comes the kicker. The release says not only is refusing a test illegal, but it also hinders efforts to keep Colorado roads safe from impaired drivers. That's what got me when they say hinders efforts, because while I detest people driving drunk, you still, in this country, have rights. So I wanted to get a legal perspective on all of this. So I invited criminal defense and DUI attorney Kevin Churchill to tell us what your rights are and what you should do in these cases. You can find him at denverdui.com, and I'll have a link to that in the description of this show. Kevin, thanks so much for being here on the world-famous Driving You Crazy podcast.
Thank you so much for having me.
All right, Kevin, so you have countless years of experience in these DUI cases. What made you want to get into this type of law?
Well, fundamentally, I'm a trial attorney. So when I went to law school, I wanted to be an environmental attorney, but that turned out to be an incredibly boring subject. Okay. My advisor at the time said, "What do you want to do with your body every day when you get out of bed?" And I said, "Well, I want to go to trial." And he said, "Well, you should be a criminal attorney then." And then from there, once I was a criminal attorney, I saw how many people were being falsely accused of DUI and how complicated that was for people to work through on their own. And so I've just gravitated toward that, and the vast majority of my career has been doing DUI defense.
Yeah, and I would think that here, especially in Colorado, DUI isn't just alcohol. There has to be a lot of pot DUIs too.
Absolutely. Prescription drug DUIs, any substance of any kind that causes impairment can be the basis of a DUI, even if it's a valid prescription. A lot of people don't know that. They come to me and they say, "But my doctor gave me this prescription." And I said that doesn't matter from a DUI perspective. If it causes impairment, you can be charged and convicted of DUI.
Yeah. So when when you hear the Colorado DOT, as I was laying it out in your intro, says refusing a DUI test hinders their efforts to keep roads safe. What is your reaction to that statement?
Well, I think you have to look at it from either the prosecution and law enforcement perspective or from the defendant's perspective, right? So from a prosecution and law enforcement perspective, that's absolutely true. From a defendant's perspective, it may or may not be a good idea to submit to a test. Most of the time, it's better for the defendant, the person accused, to take a test, but there are exceptions.
What are those exceptions?
So an exception would be if someone's BAC is exceptionally high, let's say they have a BAC that's over 0.20, then that BAC causes them to have a mandatory 10-day jail sentence in the court case. If they come into court with a refusal, there is no mandatory jail sentence. So if someone's exceedingly intoxicated, it could be in their benefit to refuse the test. But I would say in just about every other case, you're better off taking the test.
Huh. But how would you know if you're that inebriated? Because I know the limit is 0.08 for driving. So you're talking really, really drunk. But there are people who can be really, really drunk and still function as normally as you and I are right now.
Certainly, and this doesn't speak at all to whether they make the right judgment whether to take a test under those conditions, right? Like part of the problem with alcohol inebriation is it just causes bad judgment. So not only does it impair driving, but it impairs your decision whether to drive and whether to take a test and all of those things as well.
Yeah.
So, whether someone makes the right decision, I think absolutely is affected by their ability to think clearly. So.
Right. My guest is DUI attorney and criminal defense attorney Kevin Churchill. You can find him at denverdui.com. So what the DOT was pointing to in their press release was Colorado's express consent law that states by driving a vehicle in Colorado, you automatically consent to a toxicology test following a DUI arrest. Now, even though that law states you automatically agree to take the toxicology test, you still have the freedom, as even though you suggested maybe somebody should take the test, but you still have the freedom to refuse it.
That's correct.
And so, as I understand it, the Colorado DUI law says if you refuse to take the test or cooperate with law enforcement of any kind of test, then that person goes directly to trial, right?
No, that's not correct at
Okay.
all. So when somebody refuses a test, a good way to look at it is there's two different types of law in play. One is criminal law. It's not a crime to refuse the test. Nobody can put you in jail for refusing the test. There is a consequence in terms of your criminal case for refusing, which is that the prosecutor, if your case were to go to trial, can tell the jury that you refused the test. And that's not good evidence, generally speaking. A good prosecutor is going to say to a jury over and over, why do you think John refused the test? Why would an innocent person refuse the test? This was their opportunity to prove that they weren't under the influence. What were they hiding? All of those kind of things. They can just have a field day with that at trial. Doesn't mean you can't win a refusal case, but just be aware that that can be used against you in trial. But back to my original point, it's not a crime and nobody can put you in jail under criminal law for refusing a test. Where it does violate the law is over on the administrative law side, which is what we're talking about when we're talking about the DMV and your license. If you refuse the test, you're subject to harsher penalties at the DMV. Even on a first offense, you're going to have, if they sustain the revocation, you're going to have 60 days of no driving. There's no work permit, there's no probationary license, you're just off the road for 60 days. At that point, at that 60-day mark, you are entitled to early reinstatement with the interlock device. But if you compare that with had somebody chosen to take the test, those people who did take the test are entitled to immediate reinstatement of their license. So even if they get revoked, they can get immediate reinstatement. Immediate doesn't actually mean immediate. You still have to wait for an appointment at the DMV. That can take a few days, that sort of thing. But there's no 60-day no drive period.
But then how long would it typically take to get to trial? So let's say I did submit to the test. I blow a .10, so I am definitely intoxicated according to the law. I am going to be convicted. So let's say I get arrested then, and I get to, as you said, get to keep my license for now. But at trial, my license is going to be suspended, right?
No, trial refers to the criminal process. It doesn't
Okay.
refer to the driver's license process. So a criminal case, typically any criminal case, including DUIs, typically take 4 to 6 months to go to trial. That's unrelated to your driver's license. And in fact, the criminal process and the criminal courts don't have any jurisdiction over your driver's license. The only way that the criminal process results in a driver's license result or consequence is if you have a full DUI conviction out of the criminal case. Then that conviction will make its way over to the DMV and they will revoke you. That's separate from the express consent hearing. The express consent hearing is a hearing at the DMV unrelated to the criminal process that determines whether you're revoked from that process. Now, let's say somebody gets revoked from both. They get a DUI conviction out of court. They get revoked at the express consent hearing. They only get one revocation. It's just two different ways for them to arrive at that revocation. But those revocations merge together and they only suffer one revocation.
That's interesting because it really then comes down to two separate issues here. where I think most people think it's, and I'm included in this, where it's one encompassing issue, and really it's two separate problems.
Completely separate problems, and they're unrelated to each other, with the exception that I noted, that a DUI conviction will cause a revocation. But the judge in your criminal case doesn't have any authority over your driving privilege.
Interesting. My guest is Kevin Churchill. He's criminal defense and DUI attorney. You can find him at denverdui.com. If you have any questions or comments, you can give Kevin a call or find him on his website. You were saying that people with get a 60-day, if they refuse, it's automatic 60-day loss of your license. Well, I think you and I both know there are people out there driving without licenses, without insurance, without their license plates or current tags. So I don't think that getting your license suspended for 60 days is going to be a deterrent for people actually driving.
That could be. I have clients of all kinds. I have clients that are great people that just make a mistake one time. I have clients that are heavy drinkers and just can't break that addiction and get into court repeatedly. And there's all different shapes and sizes of how this happens to people, unfortunately.
Yeah, and I want to go through in just a minute the process of what happens. Let's say you have been drinking and you see the blue lights behind you. I want to go through that in just a little bit. But I was thinking about this video that I saw recently. There was an officer who was interviewing a driver, and there was a crash. And there was a pedestrian who was killed by that driver in that crash. And while I was watching it, it was clear the officer was trying to, at least in my opinion, trying to coerce that driver into answering questions. And you could see that the driver, you're talking to an officer, so you're going to have a heightened sense of apprehension. You just were involved in a crash with a person, so you're going to have another higher sense of apprehension there. And she was read her Miranda rights, but it didn't seem to me that she really understood what she was being told, because she really didn't seem like she was in her right mind. So could it be argued that if someone is under the influence or impaired, even though they're read their Miranda rights and then they are being asked if it's okay to talk to the officers, could it be argued that they really don't know what they're agreeing to at that point because they're not of sound mind and therefore they shouldn't have any of that what they say admissible in court?
You're correct. So voluntary intoxication, which means you chose to intoxicate yourself, can still be used as a defense to being a knowing and voluntary and intelligent waiver of your Miranda rights, meaning that everything that you say can in fact be admitted into court against you. However, I would note that voluntary intoxication is not a defense to the charge of DUI itself. It is a defense to components of the case, meaning your statements that are made after you're taken into custody and that are a result of an interrogation. Okay. So it can play a role in your case. You can defend against the admission of those statements against you, but it can't be used to defend against the charge of driving under the influence itself.
Right.
If it could, then everybody who is under the influence would just have an automatic defense. Well, I just couldn't think straight, and that's why I drove, so I'm not guilty. I mean, that you can see how that would go.
Yeah. Have you ever seen any trial attorneys try that in court?
No, it's just plain and simple. You can't do that. A voluntary intoxication is simply barred as a defense to driving under the influence.
Interesting. All right. So again, I want to reiterate that I don't condone driving under the influence of anything. I have seen firsthand the devastation, especially from drunk drivers, not choosing another way to get around. And there are plenty of easy ways to get around, but I also have strong feelings for freedom and for people to know their rights. And after this news release went out from the state DOT, the police department up there in Craig, Colorado, right near Steamboat Springs in northwestern Colorado, sent out their own press release, and it was titled, "Upon Arrest, Choose to Test," basically saying that if you're suspected of being under the influence, you should take the sobriety test like a breathalyzer just because they tell you to take it. They also, at the start of their statement, said, quote, "Law enforcement across Colorado is seeing an increase in drivers refusing to take a blood or breath test when arrested for driving under the influence. Unfortunately, many people have misconceptions about this process. Here's the truth. It's illegal to refuse the toxicology test, and doing so will result in more severe penalties," unquote. Do you have a feeling about that statement?
Well, let's take it piece by piece. So the first statement is someone should take a test. That's a statement made by prosecution and law enforcement. That's what's best for prosecution and law enforcement, not necessarily what's best for the person who's accused. And so I have to make that distinction when I'm answering your question. My job is to defend the accused, and I should answer your question from their perspective.
Right.
From the perspective of the accused, it's generally best to take the test simply because your penalties at the DMV are going to be lower. And having a prosecutor at your criminal trial saying that you refused the test and really taking advantage of that fact against you isn't really helpful to your defense. So generally speaking, it's better for the accused to take a test. And as I said, the exception to that is if they do happen to be aware that they are extremely impaired and have a very high blood alcohol level, then they're only going to subject themselves to mandatory jail time by testing very high. I would call that the only exception to you really should take a test, even from the defense perspective.
Yeah, and are these penalties that the Craig Police Department were getting to, like the automatic license revocation, that has to be one of the big ones that they are pushing, but like you said, I think it comes up to the individual person and their attorney to decide what is maybe best for that person in that case.
Well, I think that's right. And, let me step back to what you said, that your license is automatically revoked. When the DMV wants to revoke your license, you still have constitutional defenses to that revocation. So the same defenses that you have in criminal court apply to the DMV process. So it's not exactly automatic. You have the right to request a hearing even if you refuse the test. At that hearing, your attorney may be able to suppress some of the evidence, all of the evidence. It could result in that case being dismissed because the officer didn't follow the law or the Constitution. And then you're correct in terms of what each person should do. I think that's based on their own circumstance and the facts of that particular case.
Yeah. And then there's a requirement to have an ignition interlock device. I've actually interviewed some folks that create those and put those in cars in previous episodes. The Craig Police Department said this is going to happen to you if you refuse the test. But doesn't that just come if you're convicted?
So again, the convicted refers to the criminal process, not the DMV process. Okay. Strangely, if you're convicted of DUI, you only suffer a 9-month revocation on a first offense. Whereas if you refuse the test and the DMV revokes you from the express consent hearing, the DMV hearing, then you have a 12-month revocation because you refused the test. So in other words, let's say a person gets revoked from a DUI conviction from criminal court, and they get revoked from the express consent revocation, then the greater of those two will hold. They'll have a 12-month revocation, and at the DMV, they'll have that 60-day no drive period, and they have to have the interlock device in their vehicle for 2 years if they get revoked from the DMV case. But let's say in the same case, the person wins at the DMV, and the only way that they get revoked is from the criminal process, then they only have to have the interlock device in their vehicle for 9 months. They don't have to have that 2-year interlock requirement. So the 2-year interlock requirement really isn't related to the criminal process. It's related to the DMV process.
Yeah, I think it's just another way for these police departments, for these law enforcement folks to scare drivers, and that's their job, to scare you into not driving drunk and saying, look, there are all of these different penalties that could happen to you. They're not guaranteed to happen to you, but they are almost stating that they are fact, that this will happen to you. You're going to have to be in DUI treatment enrollment, and you're going to have a special insurance to deal with, and a higher risk car insurance, and you might be if you get another DUI, a persistent drunk driver, those sort of things. So it's like they're trying to scare you into doing the right thing.
Yes, well, all of us defense attorneys like to have police in the world. We all have friends and family and children that are sometimes crime victims. And police do a wonderful and important job of keeping us all safe. But is it also true that when they're trying to investigate you for a crime, they can do things that make you feel pressured or tricked into providing information that really doesn't help your defense case? Absolutely. That's routine in every criminal defense case. It's routine in every traffic stop. I'll give you an example. Police, one of their new tricks is when somebody gets pulled over, they'll say, on a scale from 1 to 10, where 1 is completely sober and 10 is the most impaired you've ever been, where would you rate yourself? And if that person says anything other than 1, they're essentially admitting to driving while ability impaired, because the driving while ability impaired statute states that you drove a motor vehicle after consuming drugs or alcohol or both, such that your ability to drive was impaired, and this is the kicker, to the slightest degree. So if you say anything other than 1, you're admitting that you're impaired to the slightest degree, or at least that's the argument that can be used against you. So that's an example of how, the police are basically setting you up with a lot of their questions. And generally speaking, getting back to a question that you had asked earlier, and I don't know that we got to the answer of, in general, it's best for people to say as little as possible when they're pulled over by an officer from a defense perspective. Again, I'm not speaking from a prosecution, a law enforcement perspective, or what's best for society. I'm speaking from the perspective of what's best for the accused. What's best for the accused is to not answer any questions. The best thing to do is to open your window, hand the officer your driver's license, registration, and proof of insurance, and really say nothing if you feel like you might be in trouble.
Yeah, because I'm sure you don't condone driving intoxicated, but as a defense attorney, you said, what your recommendation would be what, step by step? As soon as they see the red and blue lights, you pull over, and whether they've been drinking or not, when the officer comes up, they're going to ask you probably one of 2 questions or maybe both. Where are you going, and have you been drinking tonight?
The more common question is, where are you coming from? That's the big one they're looking for. They want to hear you say, I'm coming from the bar, I'm coming from dinner with friends, I'm coming from the Rockies game. Those are usually consistent with somebody can be consistent with somebody who's consumed alcohol and can contribute to the prosecution's case against you. So I'll go back to what I said a moment ago. I think the best answer is to say as little as possible. Be ready with your driver's license, your proof of insurance, and your vehicle registration. Hand them to the officer and don't say another word. And the problem is, people hear their whole lives on television, you have a right to remain silent, right? We've all heard that thousands of times on television. But when you're actually in that situation, what happens is you feel like, well, if I don't answer these questions, I'm going to seem like I'm not cooperating. I'm going to look like I'm guilty, and that sort of thing. The police prey upon that. They know that's how you feel, right? They know that you're going to feel compelled to answer their questions. So you don't actually have to answer the question whether you've had anything to drink tonight. You don't have to answer the question of where you're coming from. You don't have to answer any of those questions. And so from a defense perspective, the less information that you provide, assuming that you are in trouble, and you shouldn't be driving to begin with, the better off you are from a defense perspective. Now,
but you feel like you should say something to them. So do you just say, "Hi, officer, I don't answer questions. Here's my license and registration"?
You don't even say that, because if you say a word, they're going to say, "I detected slurred speech," right?
So you just stay silent.
Stay completely silent. Hand them those items and don't say anything.
And when the officer starts to say, well, why aren't you talking to me? Why aren't you saying anything? Couldn't he use that against you to say, well, the person wasn't saying anything at all, and so therefore I became suspicious?
No, sir. When you have a Fifth Amendment right to remain silent, and that starts the minute the officer walks to your window, and it persists all the way through the end of your jury trial, if there is one. So at no time do you ever have to speak to anyone, and that can never be used against you. If your case were to go to trial, the prosecutor would be constitutionally barred from telling a jury, John didn't answer any questions. Doesn't that make him look guilty? He must have been hiding something. Yeah. Totally illegal for the prosecution to make that kind of statement.
And if somebody was pulled over and they admitted to having, hey, I was at dinner with my wife and we just had a glass of wine.
Well, that's evidence against you. You
Yeah.
just handed them some evidence against you, which really works against you in two ways. One is it gives the officer probable cause to arrest you and invoke the express consent law, they call it. That's the law that the officer is going to say to you, by driving in the state of Colorado, you've already given your consent to provide a sample of your blood or breath. Which do you choose? If you give them probable cause to do that, they can arrest you and put you in that express consent situation.
Wow. Yeah, I remember it reminded me of a time my wife and I were up in Aspen. This was before we had kids. And we were driving. I was driving on Main Street, and we had.
I need to warn you not to incriminate yourself.
I think it's past the. I think it's past the statute of limitations, because maybe this was 25 years or so ago, and we were, or 20 years, whatever. Anyway, we were up there in Aspen, and we came back from dinner, and I did have, I don't know, a couple of glasses of wine. So I'm not inebriated. I was, obviously, I had some wine. So I wasn't totally sober, but I wasn't also over the limit, because I wouldn't do that. Anyway, so I'm driving on Main Street, and I didn't realize that I had a headlight out. And so here comes an officer from Aspen, does the UE right there on Main Street, lights on, boom, pulls me over. So I pull over, and I'm not kidding. He had his head all the way in the car, when he was asking me questions, and I'm like, hi, how you doing? He was like right in my face. And I'm sure he was trying to either invoke something or trying to smell me.
Mm-hmm. Yeah, that makes sense. Their job is to collect information and make observations and report that in their police report. So
yeah,
it's all fair game. If he can smell alcohol, that's going to go in that report.
And I gave him my license, my insurance and all that. And he just said, hey, when you get back to Denver, get the light fixed. I said, no problem, sir. Thank you very much. And off I went. And it seemed like that they just want to make a lot of contacts.
Certainly. Yeah. Well, they have to have reasonable suspicion to pull your vehicle over. The taillight that was out gave them that legal justification to pull you over. Then that officer could have pulled you out of the car if he wanted to. He doesn't need any legal justification to do that. If he simply smelled alcohol, he could say, Jason, can you please step out of the vehicle and come do some voluntary road field sobriety tests? The next question becomes, with the information he gathers, does that amount to probable cause? That's the big question. That's the threshold question. If he gathers what's called probable cause, then he can arrest you and make you take a blood or breath test.
Right. Should I then just take, if he does get me out of the vehicle, he wants me to walk the line or say the alphabet backwards, which I couldn't say to you right now, mainly because I get up for work at 2:00 in the morning. But if he asked me to do those roadside sobriety tests, should I just say no thank you, because they're going to be doing the breath test anyway? Should I just say, let's skip this and just take my breath?
They are voluntary. You have every right to decline them, and you can decline them. I've never seen a DUI case, and I've been doing this for 26 years. I've never seen a single DUI case where the officer said my client passed the field sobriety test. I've seen plenty of them say they failed them when they didn't. And what's important is that nowadays they have body camera. Right. You go back 10 or 15 years or more ago, they didn't have body camera. So back then, you just had to rely on what the officer said. If the officer said you were swaying when you were doing the walk and turn test, that's the evidence. And all you can say is, in cross-examination, no, he wasn't doing that, was the officer? And that's not very effective. Nowadays, everything's recorded on camera. You can corroborate or not corroborate what the officer is saying right in front of the jury because of the officer's body camera.
Yeah, that's got to help out a ton. My guest is Kevin Churchill. He's a criminal defense and DUI attorney here in Denver, Colorado. You can reach him and find him at denverdui.com. So I found it interesting in this line. I was reading through the Colorado law, and it says, no law enforcement officer shall physically restrain any person for the purpose of obtaining a specimen of such like a person's blood, breath, saliva, or urine for testing, except when the officer has probable cause to believe that that person has committed criminally negligent homicide, vehicular homicide, assault in the third degree, or vehicular assault, and the person is refusing to take or to complete or to cooperate in the completing of any tests or tests. So they really can't make you take the test if you don't want to, unless maybe you're unconscious or dead.
That's right. So if you commit one of those extremely serious offenses, then they can force the blood draw. Or if there isn't one of those serious offenses, they can, and I've seen this a lot recently, can actually obtain a warrant to get your blood. At that point, they can use force against you. But you're right, the general run-of-the-mill case, they can't use force to make you take a test.
Unless you're dead, and then, you can't refuse when you're dead.
That's a great defense at trial.
Right. But I don't think it's going to lead to a conviction. Not many dead people are hanging out in jail, are they? Well, there's a few, but they're not there very long.
I hope not.
The part that really gets me about all of this, let's say someone who gets arrested for a suspected DUI, but isn't, like you said, it happens where officers, especially back before cameras, they were suspected, and then they were put through the process. And let's say they were suspected of DUI, but they aren't, and they don't take the test, and they don't take all that stuff. But and then the person still has to hire you, or someone like you, and then spend the money to defend themselves, and they might not even have to defend this false accusation, and that takes a lot of time and money and time away from work.
Absolutely, and that's true of any criminal offense. I think it would shock people how many people get accused of crimes generally when they haven't committed that crime, and they're all in that same boat where they have to, if they can't qualify for a public defender, they do have to hire private counsel, or if they make the mistake of trying to defend themselves. Absolutely, this happens all the time. We do not have a perfect system of criminal justice. False accusations are rampant. I see it all the time in my DUI practice.
And smaller, not like large police departments. Denver, obviously, big cities will have all the officers with those body cameras. But in smaller towns, they don't have all the body cameras. And so, in smaller towns, you've heard all the stories, I'm sure, from, in places in the South or wherever, where the officers will do what they will, and they're able to coerce the evidence, if you will, in the way they want it to be coerced.
Well, that used to be true 10 or 15 years ago. Nowadays, it's Colorado law that officers must record all of their contact with you on body camera. So even in those smaller towns, everyone now has body camera. And if they don't, you can have a field day with that in terms of cross-examining the officer. In other words, officer, you had the ability to follow the law and record your contact with my client, didn't you? And you chose not to do that. And so now this jury has to just rely on what you're saying because you didn't follow the law and procure that evidence for them. That's a great cross-examination for us.
Is it like that in most other states? Are they coming around to where the other states also have to have officers with the body cameras?
To be completely honest, I know Colorado law. I don't know the laws in those other states, but I would assume it's becoming more prevalent. And honestly, it's better for everybody. It's better for the officers. It's better for the accused, and it's just better for justice in the broad scheme.
Yeah, but I would think that in you just following this as an attorney who deals in this all the time, that you know what's happening in other parts of the country, and I would think that most of the laws are going similarly to what Colorado has that you'll see in other states around the country as well. So it's almost becoming more uniform around the country.
Well, the technology is much more accessible now than it used to be. Body cameras are less expensive. They're easy to obtain. As I mentioned, they're in everybody's best interest. Anybody who's, a police officer walking the beat or driving the beat would want to be able to prove that somebody pointed a gun at them and fired it, right? So it's in the officer's best interest. So I think without a doubt what you're saying has to be true, at least over time, if it isn't already.
Right. And I talked about this just a moment ago, but when somebody has to hire an attorney like yourself to defend them and go through this process, and whether they're guilty or not, what kind of a range of fees? I mean, there's a lot of lawyers out there, and there's a lot of attorneys out there. and I know there's a difference between lawyer and attorney, and one trial and one isn't. But there's got to be a range of fees, but is there an average of how much it might cost the average person to hire an attorney?
Well, usually when you hear online or on TV about how much a DUI costs, the figure that I typically hear is $10,000 is what it costs you to get a DUI. Part of that is your attorney's fees. Part of that is the fine the court is going to impose. Part of that is probation supervision fees. There are statutory surcharges and costs. So, and then your insurance premiums are going to go up for driving your vehicle. I think when they give you that figure of $10,000, they're kind of referring to all of that, all of those figures put together. In terms of a defense attorney, I sometimes, have people call me and say, well, I hear how much you're charging, but the guy down the street is charging less than half of that. And the thing that I like to tell them is you can buy a $2 cheeseburger and an $8 cheeseburger. And can you tell the difference? And usually they understand immediately what I'm saying. I think what you find in the marketplace is the attorneys that are busy and the attorneys that are in demand just have higher fees because that's just what the market dictates. So I would say, your fee on a DUI case, excluding trial, could range from as low as $1,500 or $2,000 to, the $10,000 or even $15,000 without a trial. And then if you go to trial, then it adds on top of that.
Oh, sure.
It's quite a range, and really, I think it's determined a lot by the attorney's experience and sometimes fairness, right? Some attorneys, I think, charge an unfairly high amount, and some don't. So it's a very difficult question to answer. It's a big market. There's a lot of attorneys, and they all charge different things.
Yeah, it almost seems like this process has become streamlined because there are a lot of people with DUIs. And so how long would this linger? Should I just go through the process if I was, and let's say I have a .10 and now I'm going to be convicted and I've paid my attorney's fees and I've paid my court costs and other fines and that sort of thing, and now I got to drive with this interlock deal. I mean, how long does all of this really linger with my higher insurance costs and all of those other issues? Is it like a bankruptcy where it's going to be off my record in 3 or 4 or 5 years?
Well, I can really only speak to the court process and the DMV process. In terms of insurance companies, I think those vary. The amount that your insurance goes up varies from company to company. How long they want to ding you for that infraction will also vary. In terms of the criminal case, your criminal case is likely going to be over in 2 to 3 months if you don't have a trial. It's going to be over in 6 to 8 months if you do have a trial. And then your DMV consequence could persist for 2 to 3 years if you have priors and refuse the test, and you have to have the interlock in your car, interlock device in your vehicle for a long period of time.
Yeah. And do you go through any of these where there's we hear so many times that a person is going with a plea bargain? Does that happen often with these, or do the prosecutors really want to get DUI convictions and they would rather not do a plea bargain to something lesser so you don't have to deal with all the DUI stuff?
Well, a plea bargain does generally result in a conviction. It's just a matter of what is the conviction.
Right.
So in an aggravated case, they may not be willing to plea it down from DUI. If it's not aggravated and, my client follows my advice and does mitigating activities prior to resolving the case, like taking alcohol classes, attending the Mothers Against Drunk Driving Victim Impact Panel, perhaps getting some character letters, talking about how they're remorseful about this mistake, that can help us to get it reduced to DWAI. In Colorado, the district attorney that's handling the case is not legally allowed to drop it below DWAI, let's say to reckless driving. A goal in a DUI defense case is to get what we call a wet reckless plea, which is you do DUI probation, but you're allowed to plead to a lower charge of reckless driving. That will only occur in an instance where they can't prove the case. Sometimes I can help them not be able to prove the case. And so if I can put my client in that position where the district attorney can't prove the case, that's when we can get below a DWAI.
Interesting. Yeah, you were. I just remembered you were talking about the meat analogy, the hamburger analogy. I was over at King Soopers 2 days ago, and I was in the meat section. And get this. So Wendy's, everybody knows Wendy's. They actually had Wendy's meat. I mean, like the raw meat in square patties that you could buy in a Wendy's package. What's the difference between that 100% ground beef and the 100% ground beef that's right next to it? That's from King Soopers.
Well, the beef next to it might be organic. It might be
right, sure.
There's going to be less antibiotics, and it might not kill you. So,
but then I'm going to have to get my square buns, and I'm going to have to find all the other toppings and stuff. I mean, why? I don't want to go stop at Wendy's to go get one of their burgers. Why do I want to cook the burger myself?
That's a good point.
Yeah,
I recommend organic.
Yeah, there you go. Okay, all right, good. So, are you not a meat eater?
So.
Okay, good. All right, good. Well, this is not the healthy eating podcast, and I'm a perfect example of that. Well, okay.
I was not prepared for these questions, Jake.
That's right. These are the hard-hitting questions that everybody wants to know. Kevin Churchill, criminal defense and DUI attorney. You can again find him at denverdui.com. I'll have a link in the description of the show right to Kevin. Thanks so much for your time. Thanks for all your insight and explaining to a layman like me all the different ins and out of this. So I really appreciate it.
Much appreciate the invite. Thanks, Jason.
All right, I learned a whole lot from that discussion. I didn't bring this up with Kevin, but I was talking to somebody that I was going to be talking to Kevin about this issue, and then they said, "Well, aren't you going to be giving people who might be potential or all the time drunk drivers or people who don't mind having a few beers or few more than they probably should, and they go out driving, give them some information on how to avoid getting a DUI or what they should do. You're giving an anarchist cookbook instruction manual to the DUI person or potential DUI person how to handle these situations. I said no, because I don't think the people that are listening to this and the people who will be driving impaired, because there still will be, are going to, one, remember this conversation and or probably seek it out. They most likely, I think, this is just my speculation, that they are better, they believe they're a better than average driver to begin with, that they are not going to get pulled over because they are going to be a better than average driver when they are intoxicated or had some drinks and are driving home. And will only get contacted if something happens to them. Let's say inadvertently they are driving through an intersection and somebody else it hits them and then they're dinged. And that's always a possibility. And I would imagine there are people who have received DUIs not because of their behavior, but because the behavior of somebody else caused them, the person who was drinking, to be contacted by law enforcement. So, yeah, I'm not worried, and I think I do actually have a copy of the Anarchist Cookbook somewhere in the attic. I should go look and see if it's up there. It might even be online. I don't know. This was forever ago when it was a thing. Anyway, so I hope you got a lot of information out of that. If you have any questions, comments, concerns, shoot me a line. You have all my contact information in the description of the show, and of course, you can call Kevin if you have a case that you might want him to look at. Thanks again for being here. Thanks for listening. And until next time, I'm Jason Luber, the traffic guy. Be safe, and as always, happy motoring.